Good morning, everyone, and thanks for being here on the SHRM Coronavirus Update webinar with myself, Sarah Lamar, and Wade Herring from HunterMaclean. We wanted to give this timely update on the latest involving this pandemic to the members. As many of you have heard already, the COVID-19 is already in Georgia, around the world. As of a few days ago, there are about 165,000 cases and approximately 6,500 deaths. The pandemic has reached 146 countries. There is a lot that we don't know about COVID-19. In part, we're still learning how it spreads. There have been recent studies that show it can stay on hard surfaces much longer than initially thought, especially plastic and metal. It's understood that it stays on those surfaces for up to 72 hours. On cardboard, which Amazon will be happy to know, it stays on cardboard less, more like 24 hours. And there's a better understanding of how you can contract it. Initially, it was thought just droplets from coughs or being around someone who has a fever. Now there are studies that showing the droplets themselves can stay in the air for some time and take minutes to actually fall to the floor. So this is really our most serious public health threat since the 1918 flu pandemic that lasted about 18 months. And there are also concerns that it has a broader reach in terms of affecting young adults and children. But I think Wade's going to talk a little bit more about that. Wade, you had a few comments you wanted to make.
I do. This is Wade Herring. Many of you know me already. As we think big picture about what we're up against, I think you have two primary goals. Goal number one is the safety and health of your employees, and no one is better suited than HR to take care of that goal. And the second goal is helping the business survive. In terms of sources of information, the SHRM website is excellent, and they've been doing a great job of doing some webinars, and I highly recommend it to you. The CDC is also a good source of information. In terms of who from the administration is out there in front of the public, I recommend Dr. Tony Fauci. Many of you have probably heard and seen him. DOL websites, in terms of these employment laws that apply, remain a good source of information. And I would specifically commend to you the ADA website on pandemics. And if you Google ADA, pandemic, and EEOC, it will pop right up. It's done in a question and answer format. It's excellent. It was created in 2009, but the information is still current and valid and applies. So in terms of addressing the safety of your employees, how do you do that? There needs to be ongoing communication with multiple platforms. The communication should be affirming, calming, but also realistic. I am concerned that people continue to downplay the seriousness of this problem. Of course, the basic things that I hope we're already reminding our employees about: to wash hands, to use sanitizer, to do extra cleaning in your workplace. I hope you're doing those things already. Giving employees the option of working from home, and if you don't have that built into your capacity yet, that's a priority. In some workplaces, working in person, though, remains the most efficient and the most practical. Some places you can't work from home. So an option there is to work in shifts, to create an A team and a B team, maybe even more teams than that, and to allow people to split days or to split weeks, etc. I think we're going to have to get way out of the box. And when I talk about working in shifts, I'm talking about white collar office environments as well as other kinds of environments where that was more common. We do not yet have a confirmed virus case in Chatham County or even in our region, but if you listen to the science, that is coming. And so there may be a time when you want to take, if you're still allowing people to come to work, you may want to take people's temperature as they come in the door. We're not there yet, but we may get there. I looked yesterday on Amazon, the handheld sort of radar gun temperature sensors are still available and ready to ship. The cheapest one costs about $80 and they go up from there. Whoever gets the lucky job of taking other people's temperatures, you need to make sure that person is protected with gloves and a mask, maybe a face shield, etc. But that's something you should go ahead and be thinking about if you're having people come on site. If people appear to be symptomatic, you send them home. And yes, there are ADA issues, but we're in a pandemic and the safety of your employees comes first. And then when we do, I think as we move ahead, if we have confirmed cases in our region, then you would be allowed to ask people, have they been exposed? And if you have vulnerable workers, you start talking about sending those vulnerable workers home. Finally, in terms of survival of the business, sadly, those of us who lived through 9/11 and the Great Recession have lessons learned from those experiences. I do not want to be alarmist, but I think this is worse. But what I learned from 9/11 and the Great Recession is you need to act decisively. And if you're going to do cuts, dismissals, you need to go ahead and do that and do it as deeply as possible. What is worse for your business and what quite frankly is worse for your employees is the death by 1,000 cuts where you're doing rolling layoffs and everyone's sitting around waiting for the other shoe to drop. It's terrible for morale. It's terrible for your leadership. It's terrible for your employees. My recommendation is to make the hard decision and to make it sooner rather than later. So that's my big picture overview. And from that, we're going to go into some of the specific laws that apply. I know everyone has questions about the bill that's just passed the Congress. The president has not signed it yet. He did sign it.
He did sign it, yeah.
So the president has signed it. It's going to go into effect in not less than 15 days, which we're not sure what that means. But what it does mean is you've got a short window to start making some important decisions. And with that, I'll turn it over to Sarah.
So the Families First Coronavirus Response Act, which is going to be added to our ever-growing list of acronyms in the employment world, was signed last night by President Trump, and it has many elements to it that relate to feeding needy families and unemployment insurance and free testing for coronavirus, etc. I'm going to focus on the three elements I think that are most relevant to talk about with this group. The first issue is a tax credit, and I'm just going to briefly talk about that for paid leave that you give your employees under this law, either sick leave or FMLA leave, is supposed to be a tax credit from the government on those payments. So in theory, employers are not out for making those payments. Of course, they wouldn't come immediately and you'd be payrolling these payments long before the government either set off other tax obligations or gave you a refund. So the other two primary elements are paid sick leave. The law initially applies to only those employers with less than 500 employees. Now, that may seem to be contraindicated. Why are the biggest employers, who are perhaps the most able to sustain these types of difficult circumstances, excluded from this act? And that's a great question you can talk to your elected officials about. So we've got less than 500 people in your employ. You have to give 80 hours of sick leave for one of 6 reasons to each employee, full-time or part-time people as well, of course, on a prorated basis. So these are the 6 reasons very quickly. I'm sure you could find them online too, so I'm not going to detail, but if you're subject to a quarantine, you can't come to work because you're subject to a quarantine or isolation order from a government entity. You've been advised by a healthcare provider to self-quarantine due to COVID-19 concerns. You have COVID-19 symptoms and are seeking a medical diagnosis. You are caring for an individual, not just a family member, but any individual subject to a local quarantine or isolation order, or as advised by a healthcare provider due to COVID-19 concerns. Importantly, you are caring for a child if the child's school or daycare has been closed because of public health emergency, or if you're experiencing any other substantially similar condition that the Secretary of Health and Human Services may determine, which no one's determined anything yet because this is far too new. So that's the paid sick leave element. You are only entitled as an employee up to a maximum of $511 a day, which is pretty high if it is for your own absence due to coronavirus, and up to $200 a day if it's essentially for caring for others. So that's $511 a day. And again, that's going to be a pretty highly paid person who would meet that limit, or $200 a day. You cannot mandate under this law that employees use their PTO sick vacation first, although the employee can do that if they want to, but you cannot mandate that. The second big picture item is an amendment to the FMLA. This also has the less than 500 employee threshold. That's who it applies to. And here the FMLA is again amended to say that an employee is eligible for this leave if they have worked for the employer for at least 30 days prior to the leave. So all those requirements, 12 months, 1,250 hours, works in a location with 50 or more folks within 75 miles, all that's out the window for this. It's 30 days employment is all that's required. And what this allows is 12 weeks of job protective leave if you have to stay home because you have to take care of a child whose school or daycare has closed. You are entitled to up to 2/3 of your pay, up to $200 a day. The first 2 weeks are unpaid, but the thought is that's covered by the sick leave provision, and the remaining 10 weeks would max out at the $200 a day. The law says that the DOL may exempt small employers from the job restoration requirements of this provision if it may cause kind of a crisis in employment or in the business. Significantly, healthcare providers are exempt. This means that the employer of a healthcare provider, as defined under the Family Medical Leave Act, can decide not to allow that healthcare provider to take leave under the sick leave and the FMLA provisions. This is not a broad exemption for all employees of a medical practice or hospital, but it is focused on what appears to be a desire to have our healthcare providers working and helping the community at large, as opposed to staying home. Wade, what am I missing?
Well, I do think it's important to emphasize that the employee has the choice about how to sequence any paid leave the employer has already granted, and that paid leave would be in addition to this paid leave, which is mandated by the law. Another thing I think that's important in terms of making your decisions is that, as one would expect, there are various anti-retaliation provisions in this. And so if you're laying people off once the law becomes effective, and it's not effective yet, but it's going to be not later than 15 days. Again, we're not sure what that means. But if you're laying people off because you don't want them to be able to get this once the law is in effect, it's not in effect yet, then there's the concern about anti-retaliation claims. And in terms of the Department of Labor doing anything to exempt smaller employers, I wouldn't hold my breath. I don't think they're planning ahead at all. I don't think they've got a handle on this. And what the bill says is they'll issue regulations. Whatever they do is going to be too late for most small businesses.
There is, in addition, some notice requirements that the Department of Labor is going to promulgate about these leave options. So be on the lookout for those as well. And the job restoration provision, there is a more explicit provision for the smallest of employers, fewer than 25, who will be generally excluded from the job restoration, or may be excluded from the job restoration requirement, but they still have to make efforts to reemploy the employee who took leave. So that's the big overview of this bill. Just as a backdrop, it was only passed by the House on Saturday morning in the wee hours. It had a few changes and went to the Senate on Tuesday. And by Wednesday, the Senate had passed it and President Trump had signed it. So to say that this was hastily put together, I think, is probably an understatement. And there may be gnashing of teeth and wringing of hands about what they've done to the small and mid-size employers and businesses throughout the country. But hopefully, again, that's not the case, but it certainly could be.
There's a question pending about what is the requirement for certification if someone is taking FMLA for childcare. And under this new law, the provision is actually if you need to take care of a child because school has been closed. And folks, all the schools in the country are basically closed. They're certainly closed throughout the state of Georgia. So anybody that you have at home, anybody that has school-aged children at home, theoretically could take this leave. So you're not, from the employer perspective, you're not going to be able to mandate any certification for that. Let's talk about if somebody's sick. One of the reasons this is such a concern is because the healthcare system is in crisis. So the idea that you're going to get a doctor's certification because someone's is symptomatic or is being tested I think is wishful thinking. That's not going to happen. This is going to require that you trust your employees, but the usual process of getting a medical authorization or certification is not a realistic prospect.
In terms of the Families First Coronavirus Response Act, that was certainly the broad overview we wanted to share with you. The WARN Act is a next law we wanted to discuss. And the WARN Act, if you are not familiar with this law, requires an employer to give 60 days notice to its employees of a plant closing or mass layoff. The WARN Act is kind of like the ADA. It's a layer cake analysis. You meet one level, then you go to the next, then you go to the next until you get to the bottom. So the penalties for WARN Act violations are quite severe. If you fail to give the notice and you're a covered employer, you have to pay your employees the 60 days of pay and benefits that they miss, plus attorney's fees, plus fairly hefty penalties that can be levied against the employer on a daily basis. So this is not a law that you want to casually examine if you're considering laying off people. So for starters, let's talk about who is covered by the WARN Act. An employer is covered by the WARN Act if they employ at least 100 full-time employees. Now, before you get comfortable about that, the definition of full-time is a little weird. So full-time does not include employees who work less than 20 hours, which we obviously would think would be considered part-time on a regular basis, nor does it include employees who have been hired in the last 6 months before the notice was to be given. So you could have a workforce of many, many full-time employees who were recently hired, who may take you under the coverage threshold for WARN. So it's important to make sure you know, are you covered or not? And then the next layer of the analysis is, are you undergoing a plant closing or a mass layoff? And in essence, a plant closing is a permanent or temporary shutdown at a single site of employment. And a single site traditionally means like one factory or one office, one retail store. But things can get a little tricky as to what is a single site if you have buildings that are next to each other, or buildings across the street, or the same staff works at 2 buildings, a half a mile away from each other. So when you look at the campus environment or multi-building environments, you need to consider, are these a single site or not? But the plant closing is a permanent or temporary shutdown of a single site of employment where in a 30-day period, at least 50 or more full-time employees are terminated or laid off, and I'm putting an asterisk next to the laid off. Termination, layoff, massive reduction, over 50% reduction of your pay, can be called an employment loss. And that's another layer of our layer cake analysis of the WARN Act. So you have to have an employment loss associated with a plant closing or a mass layoff. And an employment loss includes, of course, a termination, again, a more than 50% reduction in hours, or a layoff that lasts more than 6 months. Those are the definitions of employment loss that would trigger a plant closing. So if you have 50 or more people, for instance, who are terminated in a plant closing because of coronavirus, and you're a covered employer, then you need to consider giving the WARN Act notices. I know.
Let me talk to the exceptions.
Yeah.
So again, in terms of whether or not WARN applies to your business, the first threshold is 100 or more employees, and then you get into this layer cake of definitions that Sarah alluded to. But if you're covered, that 60-day notice period means you tell them 60 days ahead of time you're going to lay them off, and then in the meantime you keep paying them. That's what that means. There are a couple of exceptions, 3 exceptions, but 2 are pertinent here. One is a sudden, unforeseeable economic event, crisis. And then the second one is a natural disaster. And the natural disasters that are listed are sudden natural disasters like tsunamis or earthquakes or hurricanes. I would argue that this perhaps fits within a natural disaster as well. I certainly think we fit within the sudden economic crisis, and I'm paraphrasing the language of the statute. But here's the thing. The longer this goes on, the harder it becomes to argue that it's unforeseen. And we saw this happen to businesses during the Great Recession. The longer the economic situation stretches out, the harder it is to say, I didn't know this was coming. Right now, we're still within a week, 2 weeks of some of the emergency measures the government has issued and some of the restrictions on interacting with one another in group meetings. You've got a window, again, you've got a window of opportunity here where you have to give the notice and you can explain it's because of this economic crisis and because of the pandemic, but you don't have to give the 60 days. And given the situation that we're in, normally employment lawyers would say, no, you need to give the 60 days. What I'm saying is, if you're in crisis mode, you got to give the notice, but you do not have to give the 60 days. But if that's the rationale you're going to choose, one more time, you need to go ahead and act.
So the other basis for a WARN Act notice trigger is called a mass layoff. So something that's not a plant closing, as I've just described, but a mass layoff that includes at least 500 people at a single site, or at least 50, and those people represent at least 33% of your workforce. And again, an exception to that is a temporary layoff lasting less than 6 months. But to Wade's point, we don't really know how long this will last. So if you're relying on that exception, it's kind of a buyer beware situation, because the longer it lingers, the less comfortable you might be that the 6 months you're going to bring everyone back within 6 months. So that's what we wanted to talk about with respect to WARN. And we have a couple of questions coming in, but why don't we just keep going and we'll address those at the end. Wade is going to talk about a few discrimination issues relating to coronavirus.
Sure. So in the background of all of this angst is the usual employment discrimination laws, the usual discrimination laws, of course, being those that create the protected categories: race, sex, color, age, national origin, religion, disability. And so as you consider about how to treat employees and how to move forward, all of those protections still apply. And if you're getting to a situation where you're going to lay people off, furlough people, etc., then you need to keep those protected categories in mind. And my recommendation to you would be to come up with a set of criteria for what's important to keep your business going. And so I would expect you to have things like performance history, flexibility of skills, criticality of skills. You might look at length of service or seniority, but quite frankly, that's of lesser concern. That raises the question, in terms of your criteria, do you have weighted criteria? Does everything count the same? But basically what you're going to do is do some rankings to make your decision, and then use those rankings to make your decision about how you lay people off or furlough people or reduce work schedules. For larger companies in normal circumstances, before you made your final decision, we would want you to do a disparate impact analysis using a labor economist, a consultant. I'm not sure there's going to be time for that because you have to load in a lot of data in order to do that analysis, because you have to compare the full universe of employees against the number of employees who've been selected. I think certainly you should be, as you make your criteria and as you make your selections, at the very least, you should be doing a real world check. Are we having a disparate impact on our older workers, which quite frankly is what usually happens? Are we having a disparate impact on our female employees, on our minority, our persons of color, et cetera, employees? So at the very least, if you don't do the more sophisticated statistical analysis, you at least do a gut check. Who is it that's getting picked here to get laid off? I've already alluded to the ADA and the pandemic guidance, and folks, we're there. We're almost there. We've got a question here about temperature taking. Is it best for the company to do it or to rely upon the employees? You know, in an ideal world, you would rely upon employees, but that requires a lot of trust. There's another question about if people are symptomatic but they haven't been tested. Folks, if they're symptomatic, send them home. You do not want them in your workplace. That's challenging now because we're in allergy season. But if they're symptomatic, you send them home.
Another question that came in on the SHRM listserv earlier this week was, can we make it mandatory for at-risk, which might be, workers over a certain age, to stay home? And I think the best practice at this point is we're not there yet, and so it is not advisable to do that at this time. However, as if things change, Chatham County gets cases, we may really need to reevaluate that situation. And that's essentially, I think, what the CDC guidance says, is that we might get there, but we're not there yet.
Another caveat I would add about at-risk employees, and one would presume those are persons older than 60, but some of the scientific information that was coming out yesterday is that this may have a bigger impact on young people and on children older than 5, weirdly. So we don't, because this is evolving, I think both legally and ethically, it's important not to make unsubstantiated assumptions about who's at risk. I think we should be acting as if we're all at risk, quite frankly.
Yeah.
And if you've got young people at home from college who don't understand that yet, you need to have a serious discussion with them.
I think there was a question up top, Wade, that someone asked.
That question is about, I've got it, about communications if someone does test positive. or is being tested. I think if someone is being tested, I quite frankly, again, where we are right now, I would restrict that information. If you have someone who tests positive for COVID-19, I think you have to communicate to your workforce that that has happened. Certainly the people who have been exposed to that employee. The challenge is, though, you may not know who's been exposed. So again, I think we're in a much different place. Normally, you would never share information about somebody's illness. This is different, and I think you would communicate that. The question also says, can we limit who communicates it? Certainly among the leadership team, you need to have a designated communicator, and you need to decide who will communicate these messages. You can ask the employee not to communicate it, but I'm not sure. You can ask, but in reality, I don't know what you're going to be able to do to enforce
Right. Next discussion was about the Fair Labor Standards Act, and this is really much more so an exempt employee discussion. If folks are working, well, not entirely, but I'm going to focus on the exempt employee issue first. How much leave, if they run out of leave and they're doing a little work, do you have to pay them or not? And the short answer to that is yes. So if you have employees who are, say, working from home and they've run out of leave, but they're still performing any services during the week, that's the one email example that they returned, then you have to continue to pay them their regular salary. If they take time off, absent this new law that has just gone into place, if on the other hand, they're taking time off in full day increments and they've exhausted all of their paid leave, then you don't have to pay them. So there's a difference between if the employer says, I don't want you to work, exempt person, and if the employee says, I don't want to work. So go ahead.
Again, we learned a lot of lessons during the Great Recession about how to keep employees employed, but avoid legal problems like Fair Labor Standards Act. So in terms of your exempt employees, one option might be to cut their pay. Remember, though, that the new salary requirement is $635 a week, so it's higher than it used to be. That would be one option. Again, you need to consider, if you're going to cut people's pay, you need to keep in mind the discrimination laws. But I would also quickly add this doesn't necessarily mean you treat everybody the same. You may have business reasons for treating people differently. So for example, one easy, quote, easy solution would be to cut everybody's pay across the board, 10%, 20%, whatever, keeping in mind the salary requirement for exempt employees. But here's the problem with that. A 10% cut or 20% cut for a lesser paid employee is in reality a bigger bite on that employee's economics than it is on a higher paid employee. So could you come up with different levels of percentage cuts? Absolutely, yes. Again, normally we would never recommend this, but another possibility would be converting exempt employees to non-exempt employees and only paying them for the hours worked. The challenge there is if they're going to be working overtime, then you got to pay them overtime. And there's some things you could do with guaranteed salary for a non-exempt employee where you're only paying half time for the hours worked in excess of 40. Certainly among your leaders and your managers and your supervisors, if you're going to be in these kinds of times, you're going to be asking them to do a lot. So before you quickly convert everyone to non-exempt, think about the overtime implication of doing that, as well as, of course, the economic implication of doing that. So those are the primary Fair Labor Standards Act. For the non-exempt employee, of course, if they're not working, typically they don't get paid.
And just as Wade said about the minimum annual salary for an exempt person, $35,568 a year, if you're going to cut the pay of your non-exempt people, of course, you don't want to impact minimum wage. So you've got to still pay the minimum wage and any overtime. But is it proper to tell your non-exempt people under no circumstances are you to work overtime during this crisis? Absolutely. But that needs to be communicated to everybody so that every manager gets that message as well.
And just one other word about Fair Labor Standards Act. In a time of crisis, you'll get people who will volunteer to work without pay. I think that's a very bad idea, and it would absolutely be a violation of the Fair Labor Standards Act. Somewhat tangentially related to this is the idea of putting people on leave but not terminating their employment so that they can keep their group health insurance coverage. There's a challenge there with that. Now we've got these paid leave requirements for businesses less than 500, so that's one challenge. Another challenge is within almost any group health policy, there's going to be an eligibility definition tied to active employment. And a short-term leave isn't going to negate that active employment requirement. But the longer this thing stretches out, then you may be at risk of negating the active employment requirement. And if you have people who are getting seriously ill and making catastrophic claims, our friendly insurance industry will look at those claims very closely to determine if the claimant was an eligible covered person. So as much as people want to be nice and take care of people, there's some real challenges about how you do that and at the same time minimize risk for your business.
And to follow up on Wade's point, the one very formal and effective way to address that maybe gray area with folks out on a temporary layoff or furlough is to amend your health plan. Assuming you get buy-in from your broker and your carrier, you can amend the plan to expressly cover those people if that's what you and your business leaders think is the right thing to do. So there's a way to do it. It's not impossible, but don't assume that folks on temporary layoff will be covered indefinitely under the group plan. Of course, laying people off or substantially cutting their hours is a triggering event under COBRA, so that's always an alternative to put them on COBRA during a layoff scenario like you would for a termination.
And one other real world point I want to make is absolutely, if you're trying to do these workforce reductions in a way that maintains the group health coverage, COBRA, of course, is there, but I'm talking about the group health coverage under the employer's plan. We want to keep this person classified as an employee. You need to have that conversation with your insurance agent or broker. I can tell you, though, based on real world experience, unless your plan explicitly addresses this issue, your insurance company or your insurance broker's willingness to give you a written commitment is going to be, let us say, limited.
which goes back to maybe you have to formally amend it, but then whether you'll be able to mid-year is another question. So on to the next topic of OSHA. Wade's touched base on some OSHA guidelines already. OSHA does have a useful website on COVID-19 and general requirements. So I would urge you to check that out. Obviously, there are some more specific rules that relate to various industries, like the healthcare industry during this pandemic. But they're essentially the general duty clause under OSHA requires that each employer provide a reasonably safe workplace for its employees. The OSHA website talks about the various risk categories of employers, going from, the healthcare provider on one end that would be subject to, bloodborne pathogen rules, all the way down to, say, the office environment that would not. There's clearly the requirements of personal protective equipment must be followed, and there's been a particular focus on, as Wade suggested at the beginning, how do you protect the person who's, say, testing employees or running temperature checks of employees if we get to that point. Generally, an employee can't say, I'm not coming to work under OSHA unless they're in imminent danger of harm or there's a direct threat of harm. And of course, that direct threat analysis would also could potentially apply to the Americans with Disabilities Act. And the thought is that right now, really, there is not, in most workplaces, a direct threat, or there is not imminent danger. Could that change in the coming weeks and months? Yes, it could. The NLRA, the National Labor Relations Act, has some input here, and under Section 7 of that law, which of course applies to both union and non-unionized workplaces, that employees have a right to engage in what's called protected concerted activity with respect to the terms and conditions and the wages and hours of their job. So if two people get together and say, I'm scared to come to work because I don't think my employer is doing enough to keep us clean or safe during this pandemic, the initial response should not be to fire them, because that might be, probably would be, frankly, a violation of the National Labor Relations Act. So there's some, coaching, collaborative work that hopefully you can do with your employees to make them feel like going to work is not going to endanger them. And that includes lots of communication about what we're doing proactively and how we are continuing to address the issues. For instance, a month ago, if an employer probably wouldn't have canceled a 25-person meeting in an office, a quarterly meeting, say, because that wasn't part of any protocol or guidance going out there. But today we have the please don't get together with more than 10 people guidance. So in that respect, if you as the employer are still trying to have 25, 50-person meetings, your employees may say to you, I really don't think that's a good idea. And they would probably be right about that. The only other thing I wanted to mention was there's a great SHRM article that came out over the weekend about cleaning up after coronavirus exposure. And they quote some OSHA experts on that, and that really this is also a changing phenomenon. What do you do to clean up? Do you shut down the whole facility, or do you use more measured responses? So again, it depends on the situation, but I would commend you to look at that article. It actually came out March 12th, of 2020, and it's on the SHRM website. Anything, Wade, to add on OSHA? We have a few more questions. Let's make sure. We did have a couple questions that came via just snail mail that I wanted to cover. One of them was employers with large populations can't work from home. Who can't work from home? What are employers doing to help navigate communication and resources in connection with COVID-19? I'll just speak initially to that. I think that, again, the constant communication about what you are doing that will be changing as this virus changes and requires us to adapt. So proactive communications to folks, and it might be that it comes to a point where you have to send people home and they don't have any work to do, and you have to send them home. Then you start looking at your paid leave policies and go back to the exempt, non-exempt scenario.
And that also goes back to what I said before. In addition to the communication, really walking the walk. So if you didn't already have someone hired, you hire someone to do extra cleaning of surfaces in the workplace, not just that cleaning crew that comes in at night. And you think about, how can I divide this workforce up into shifts? And that's important not only for right now, before we have cases in our region, but afterwards. Because if the exposure is on a particular shift, then that becomes easier to isolate people than if everyone's still working the exact same schedule. You've got some bigger challenges there. So again, this is rapidly evolving, but those are some of the things I'm hearing about people doing in terms of what do I do with the workforce that still needs to come in. Another thing you might think about is in terms of absolutely, you're not allowing people to congregate in a particular area. If you've got donning and doffing requirements in your workplace, maybe you do stagger that out. You don't want everyone in the locker room at the same time, that kind of thing.
Another question that was on the listserv earlier this week, and it's amazing how things have changed in just 4 days, was if a person is out of paid leave and they're exposed to COVID-19, are companies still required to pay them for being out? Well, the answer on Monday, when this email was sent, was no, but the answer today, given the new law, if you're a covered employer, is yes. You would be under the sick leave, the 2 weeks of sick leave, and then maybe they get FMLA, the traditional FMLA, not the new FMLA, but the traditional FMLA for the remainder of that time. So that again, that's a new answer to a question from just a few days ago. We were hoping to end this on an amusing note here with one of the Muppet characters, but I think that's all of our questions. Are we done with the questions? Okay. Well, Wade and I and HunterMaclean want to thank you very much for staying with us, and we are recording this session, so we will make it available to SHRM, and we'll work with SHRM on doing that. Wade, do you have any other final thoughts?
Be well and be safe.
Yeah. Thank you so much.